your lordship thought, looking at the advertisement, looking at the nature of the appointment, he said it is permanent. He is covered by Abdul Hakim, and therefore he is entitled to a career advancement. While doing so, your lordship in the last paragraph said that he will be entitled to all pensionary benefits. Your lordship may see that order at page 17 and page 19. Para 8, your lordship will see, and then para 9. We therefore allow this appeal on the same terms as indicated in our judgment and order dated 28/2/19, passed in Abdul Hakim versus so-and-so, reported in so-and-so.
But this order was issued in your presence.
Yeah.
This order was dictated in your presence.
That's right. Your lordship is right.
And you have not sought review.
No, I have, your lordship, I have asked for a clarification that this is not entitled. So your lordship issued notice. On this, your lordship issued.
That is a mistake.
No.
Dismissed.
But the first, it was a mistake here.
Dismissed. Now come to the contempt.
Your lordship will
Come to the contempt.
Well, this is, I can quote your lordship.
Mr. Mishra, this is a very devious way of getting to the court. When it is dictated in your presence.
But this was not an issue for the High Court, not an
whatever
issue
it was, that was the reason why it was segregated, whether they're temporary or not.
Correct.
Now you want to say that there is no scheme.
No, I'm not saying, sorry. I'm not, he's entitled to the, I'm not arguing on that. I'm not arguing on that.
How long did he work?
But he worked how many days?
It was 2007 onwards, he was there, my lord, till 2016.
He is under this. It is 11 years. He was in a self-finance scheme. It's a non-pensionable service.
So there must be a CPC.
Yeah, that is given. Provident fund gratuity is given. But your lordship has said pensionary benefit. It's not a pension. Therefore, the High Court in Amaladu, which your lordship have found, High Court, these are the teachers of the SFS on as if they are unaided institution.
In fact, the court in another matter.
Yeah.
I think you too had appeared.
Correct.
The self-finance institutions and the states.
Yes.
Appeals were dismissed, right?
Yeah, that's right.
What is the effect of it? The state will have to take over all the responsibility.
No, that's right. Your lordship is.
The state will be here also.
The High Court in that.
Apart from this, if I am not wrong, all those other matters were also before us.
Correct. On the same day.
Same day. Where there are those orders.
Yeah, that's the order, your lordship. Look at that order. 134.
Because you have been playing the state and the self-finance institutions are nothing but a front of the state.
But that
is what we had actually concluded.
No, my lord, your lordship.
You wanted to get rid of your responsibilities and set up these institutions.
Lord, I am telling your lordship, we have not.
Let's see page 140.
Yeah, 140. Can I read those directions of the High Court? After considering the entire controversy, the conclusion were arrived in segment 12 of the judgment is under. 12 minutes.
No. 1 minute.
The bottom.
The action of the, read the top.
Okay. The action of the university in accord with the government to form a society and terminate the employees of SFI on the ground of abolition of post, which while the institution are carried out under the newly formed society's max legal merits.
One
140, yes. Can I read, madam?
Yes.
It is for an oblique purpose and indirect object, which is to set at naught the inter-parties judgment of this court and the Supreme Court in various litigations, even prior to the writ appeal 442 or 14. It is a direct affront to the rule of law and at least expected to an instrumentality of the state. The decision of this court in writ appeal and the connected cases affirmed by the Supreme Court is attempted to be circumvented by this action. We, however, do not fault the formation of the society or the transfer of the institution and the courses, which is a policy decision. but the permanent employees of the university are to be deployed to the society as per requirement on the very same terms and express employees retained in accordance with the law. There can also be no transfer employment unless the consent of employees, as has been declared in Jawaharlal Nehru University. The measure of transfer, though found to be actuated by legal means, this court would not interfere with the formation of the society, but to obliterate the malice, it would be appropriate to direct the university to deploy the employees with their consent to CPAS in accordance with the present requirement, but on the same terms and conditions they had with the university. Those whose services are not required will be terminated by retrenchment on the terms we will presently put forth, and those who do not consent, the terms of payment of gratuity and 6-month notice pay as provided in the statute. Now, let us look at. After considering the entire controversy, the conclusion will arrive in segment 12 of the judgment as under. That they have set aside the termination order, my lord, the High Court has. That's what quoted. Now, look at 2. Read appeal and the claims of the appellant shall stand rejected, and the following relief and directions shall not apply to them.
That finally was set aside, no?
Yeah.
We restored the single judges.
Correct.
Which means that they were taken back.
Yeah, that's it. I'm not
They were
disputing.
taken back. Whatever is the condition that they were in, you will extend to him also because of his judgment.
That's right, Lord. I'm not disputing that. Kindly look at what is I'm disputing. I'm disputing that this is not a pensionable service. High Court doesn't need. High Court doesn't say it's a pensionable service. Look at what para 12, Roman 4. Look at that. We declare the appellant should be permanent employees of the university, having the status of the teachers of the self-financing institution, which has the status of an unaided affiliated college managed by the university. An unaided college is not pension, madam.
Government is involved in this. Government is involved. Now it has gone to SEPA. That decision was finally set aside.
I'm not.
You take the aid of the government and give whatever is due.
Well, kindly look at this
This is actually what you are now.
These are the
third inning to do what was held to be wrong by the single judge.
No, I tell you, this is not the subject matter here. Here, the subject matter is whether an employee who is retired is entitled to pension.
The man resigned his job in Pondicherry and came here. At that time, you said he is not even a permanent employee.
That's right.
Now, so why did he come? He's a fool, according to you, to take up an employment for which there is no pension. Firstly, he's a fool because he takes up temporary employment. Then after that, when he succeeds, he has to run another hoop. He has to prove that he is not a fool because he took up permanent employment in which there is no pension.
That's right, but he came to know that this is an unaided college which there is no pension. But before him, many people have retired. Nobody has got pension.
Wrong statement.
In fact, as per the
What about Hakim?
What is Abdul Hakim also, he got AICT scale of pay, but no pension.
Where have you said that?
But your lordship, I have said so in my application. And in Abdul Hakim, your lordship never directed to grant pension.
Where have you said that? Hakim has never got it.
Yeah, but your lordship, look at that application, my lord. Your lordship, look at page 3, para 4.
No, that's the order doesn't say anything. But
The order doesn't say.
may not be. But what has Hakim got or not got?
If your lordship look at para 3 of my rejoinder.
Rejoinder.
Yeah, kindly look at para 3. Just a minute. Para 3, my lord, para 1 bottom. Kindly look at para 1 bottom. I've given it. Lot of people have retired before this litigation started. Nobody has got pension. Everybody knew this is not a pensionable service.
Yes, let's see the para 3.
It is submitted that Sri Ravi Kumar B, who was one of the appellant in Abdul Hakim case, has retired from service from the appellant's Abdul Kumar case and has not been granted pensionary benefit.
We don't know his terms of service, how many years it is, how many years, what is the qualifying service?
Kindly look at those who were working in the, even forget about SIPAs, where those who are working in the self-financing scheme, it was not aided by the government. Therefore, the question of pension doesn't arise. It was, your lordships, that was not an issue for the High Court. There is no adjudication.
This whatever is dictated as you say in open court.
Sir, saying that he is not entitled. There is your order saying that he is not entitled.
My order of not granting pension. No, nobody got pension since your lordship was.
You are asking, we are not going to adjudicate on this.
No, I am not asking.
Today you are asking through a clarification and adjudication. That we are not going to.
That is because your lordship said so.
That's right, we did so in your presence. Mr. Mishra, we did so in your presence.
That was not argued, my lord.
Whatever it was dictated in your presence.
No, it was dictated, but your lordship realized that since your lordship issued.
We are not going to issue any clarification. You withdraw it. If you think he is not entitled to, you pass whatever order. Let us see at that stage.
Okay, it's all right. It's all right.
My lord, may I submit one thing, my lord?
We will do that, my lord.
May I submit one thing, my lord? My lord, may I kindly see their rejoinder affidavit, my lord, which is actually para number 8, page number 12 of their rejoinder affidavit, my lord, to this application that they have filed.
Page 12.
Yes, my lord, of their rejoinder affidavit.
Right.
My lord, the main question here was of pay revision applicable to the permanent staff of the university. That was the main prayer in the writ petition. What they have done in the rejoinder, my lord, I have never, even till today, their clarification is only with respect to pension. Now what they have done is, they have not even given me my pay revision also, in spite of the judgment of this Honorable Court from 11th May 2022. Now they are justifying it in their rejoinder, that the contention raised in paragraph number 5G, where in my reply said, I have not even received my pay revision from 96 as well as 2006. They have said it is a policy decision. It is submitted. Pay revision of 2006 has not been provided to the teachers of self-financing institution and not even to Abdul Hakim and others. Nobody in the self-financing sector was given UGC pay revision 2006. Implementation of UGC pay scale in the state is a matter related to the policy of the government. The government, while implementing UGC scale, have not extended the benefits to the teachers of self-financing institutions, not to the teachers of unaided colleges. My lord, what they are trying to prove here is they are actually getting away with the judgment of this Honorable Court in Abdul Hakim as well as...
Even though you are no longer treated as employees of self-financing, because the whole thing was seen as a hoax. Despite that, you are treating them as self-financers.
Your lordship says so. The High Court judgment is affirmed. High Court says so. It's a self-funding scheme.
No, that's why it's set aside. What are you saying? It is affirmed.
It is affirmed.
He restored the single judge's order.
No. Sorry, your lordship restored the...
PC Hakim.
Right, yes. Hakim doesn't say about 2006. Hakim says about...
Hakim doesn't say, but what is the effect of Hakim?
Hakim says that they are entitled to AICT scale of pay being permanent teacher.
Right.
Now AICT scale of pay, the university adopted for 2001, didn't adopt for 2006. They adopted for 2001, we have given 2001 everybody. 2006 is subsequent. When the litigation started, it was with regard to 2001 test, ISAT scale of pay. And we have given. Since your lordship said division bench set aside that order of the single judge.
Yes, Ms. Prasinna.
My lord, with respect to that, my lord, with respect to that, my lord, Abdul Hakim judgment may be seen, my lord, wherein they have clearly said that,
Yes,
my lord.
with it receiving, this is appointment letter.
My lord, that Abdul Hakim.
Just 1 minute, ma'am.
Sorry, sir.
University statutes, Mr.
This is your mother. I can give the statute. Statute clearly says it is not applicable to unaided teachers. Clearly states to the teachers of the department, Kerala service rule applies. Aided teachers, part 1 and part
Which,
I'll show you. Give me my.
Was he entitled to pension in Pondicherry?
My lord, yes, my lord. It was actually run by the government of Pondicherry, my lord. He was a senior lecturer there. And when my lord may kindly see his appointment order as well as the memo issued by the university, my lord. It is very clearly says that he will be governed by the
First statutes.
my lord.
He is informed that his appointment in the university will be governed by the provisions in
Yes,
Mahatma
ma'am.
Gandhi University First Statutes 1991.
Yes, that's right.
1991, where are the first statutes?
1991. That's 97. What is 19?
Statute is there, 1987.
1991. My lord is saying 1991.
Not my lord, this
we are
is
not
order.
saying, this is
Yeah,
your
that-
appointment order.
That's right. Agreed, my lord. Agreed. I am not saying. Agreed.
97 only.
It is only, I'm told
How
1997.
can it be? He was appointed in 96. If he was appointed in 96, he could not have been.
Yeah, that's true. That's true. I will get it, my lord. I'll get it.
My
I'll see.
lord, my lord, I can show it very clearly, my lord. May I be given a chance, my lord?
Yes.
My lord, may I kindly see the single judge judgment, my lord, which they have annexed in page number 106, my lord, page number 106 of their application, my lord. That is the judgment of the single judge with respect to my matter is concerned,
Yes.
wherein second paragraph, my lord. In the light of the judgment in OP number so and so, that is Abdul Hakim, exhibit P12 and P4 are set aside. Petitioner will be entitled for all the benefits which are extended to the petitioners in Abdul Hakim judgment. It is declared that the petitioner is a regularly.
We will say that whatever is Abdul Hakim and the others are entitled to, you would pass an appropriate order and release it to him.
My lord.
And if you are aggrieved by that, you take it in appropriate proceedings. Firstly, there will be whatever pay, etc. Let them pass a comprehensive order saying this is what was given to Abdul Hakim. If you are satisfied, that's the end of the matter. If you are not satisfied, you take that in a writ appeal, in a writ petition.
That's right.
My lord, may I submit, my lord? My lord, he has actually spent a lot of time in litigation, my lord.
We understand, Ms. Presina, we understand. But you see, we can't make it an adjudication in contempt proceedings, right?
I understand, my lord.
We
My
are
lord,
not
may I-
clarifying. We are not clarifying anything.
I am
We are
very well.
requiring them to pass a reasoned order within 4 weeks.
My lord, I
And then
understand.
if you are not satisfied, you go to the court, and we will say that in case you are aggrieved, you approach the court will endeavor to complete it expeditiously. That's all that.
My lord, with respect to pension, I am fine, my lord. With respect to the pay revision, my lord, I have already
Not
come up.
only pension, not only pay revision, every retirement benefit, pension, terminal dues.
Provident fund.
Okay, provident fund, everything. My lord,
That's right.
much obliged.
The hearing counsel for the parties. Court is of the opinion that the applicant, Mahatma Gandhi University,
Much, yeah.
what is it fully called? Priyadarshini Hills.
The address.
Mahatma Gandhi University should make a comprehensive order, should issue a comprehensive order with respect to the entitlements within brackets, pay revision, pay revisions and fixation, terminal benefits, terminal and pensionary benefits wherever applicable, brackets closed, batch of officials, who enjoyed similar benefit, having regard to the benefits extended to Abdul Hakim and others, within brackets, beneficiaries of this court's order in CA 2388-2389/2019. So it is clarified that the petitioner shall be entitled to the same benefits. So the comprehensive order shall be made within 4 weeks. So the order shall also annex copies of the orders made or relevant documents pertaining to Abdul Hakim. So in case the respondent contempt petitioner is aggrieved by the order or any part thereof, it is open to him to seek appropriate remedies. In such event, the court is requested to deal with and decide the matter expeditiously, considering that the respondent has since retired. And is-
Well, she was the appellant before your lordship.
Here is the
That's it.
respondent contempt petitioner has since retired. So the contempt petition and application are disposed of in their above terms.
Much obliged. Much obliged.
Judicial register.
State of Tamil Nadu versus. Which one?
This is a judicial register. Is Puneet said he is a judicial officer, no?
He's a function.
उनका नाम
Order 50. Order.
item 50.
Item 50.
Office report.
Yes.
No. Yes, no. This suit has been listed. This original suit has been listed for orders. Semicolon. The evidence was recorded by Mr. Registrar of Court, who has since returned to his parent category. This Mr. Puneet Sehgal, Registrar, brackets J2, brackets is hereby nominated instead of Mr. Chirag Manu Singh to continue the proceedings.
Published notice. Item 53. May it please cross. It's a petition on behalf of, there are 13 petitioners before your lordship. In our initial documents, we've given a Google Drive link of nearly 45,000 others who would be affected. What's effectively happened, Manoj, is the announcement of NEET came on 5th January. And the NEET PG this is. The NEET PG is slated for 5th of March. Now, your lordships are aware, you need 365 days of internship experience to be eligible for this. Now, the internship cutoff is the National Board of Examinations subsequently notified that they would relax the dates of interns so that you wouldn't qualify as of 5th January, now qualify. So twice, first on 13th January and second on 7th February, they extended. At the moment, therefore, if you complete your internship by 11th August, you stand qualified to sit for the NEET.
When was that 11th August? It was earlier 31st of March.
Yes.
Now
That
it has
was
been extended to 11th of August.
First 30th June and then 11th August. That was
when the
notified
last
on
extension done?
7th February.
7th February.
Yes,
Now, in the meanwhile, these applications were open in January,
yes.
right?
Now, yes,
How many have registered? For 2
Registered?
lakh or more than
yes,
2 lakh?
2 lakhs, all of us. So we have no problem. We have also
You have no problem. What
Yeah.
about the others who have also registered and who are going to face?
No, so I'll just explain. Now, it's required as per their own info bulletin that when you go for counseling, you need to show that you have completed your internship and have a completion certificate. That's there in information bulletin. It's at page 73. That clause 4.4. Now, that means that since it's been extended to 11th August, those of us in many states, Tamil Nadu, Madhya Pradesh, etc., the internships in those colleges go on up till end of July. So the counseling can compulsorily happen only after 11th of August. We have set out a small table.
Where does it say that counseling?
Clause 4.4, if you allow me to have
3.
page 73, I'll just read that. 1 minute. 4.4, if I can read that, the dates indicated by candidates with regard to 12 months compulsory rotating resident internship in the application form, that is internship starting completion date, shall be treated as final, and candidates will be required to submit the original compulsory rotating resident internship completion certificate at the time of
The
counseling.
compulsion to have it after this. It could be before this. Those who are eligible before this also.
Yes,
They are 20, those who others
Yes.
apart from the 44 whatever 40 or 1,000 that you are
yes,
perhaps representing.
yes.
There are another 2 lakh people.
No,
who have
45,000. I'm sorry. Sorry, please complete. I'm sorry, I should have.
Those who have completed
Yes.
already
Hmm.
and are waiting for this
Correct.
are larger in number.
No, that's not right. 45,000 are those who have gotten in touch with our solicitors. And that's, we have their details and we can give that to you.
No, but there are others who have already completed.
No doubt. There
How
may
many
be.
are those? How many are those?
The numbers would be in the minority. It would be, I think, maybe 20,000, 25,000 or so. But it's no prejudice being caused to them.
No, how many have registered? I think 2 lakh.
2 lakh odd have registered.
2 lakh have registered.
Yes.
45 odd thousand have. So you mean to say that it's only 20,000 who would have completed or have completed by now?
No, so I am sorry. I just the
The
counseling in any event.
question is,
Yes, sir.
now the exam is to be held on what is
March.
March.
It's in
So
5th March. 5th of March. No, so I'm sorry. I'll just clarify.
So those
The
who
counseling-
1 minute.
Yes.
This postponement happened subsequently.
Yes.
Before the postponement happened,
Yes.
many of you were ineligible.
Yes. We were. Yeah, that's correct.
Many of you were ineligible.
Yes.
Apart from you,
Yes.
about 2 lakh odd have already applied, who are eligible. Otherwise, how would they apply?
No. So the
They would have been eligible under the old cutoff.
No, I'm working backwards. I'm saying that the counseling is not something that can be split up. The counseling will happen together, first round, second. Yes. So because compulsory as per their own rules,
The last date for receiving the applications.
that's now 12th of February. All of us have applied. All our applications have
You
been
apply,
Yes.
but very qualified on the last date.
Yes. All eligible. There's no problem with that.
How can you say you're eligible once you say that?
Because it's been
unless
applied.
you have a training,
No, I'm sorry.
don't become
So,
eligible.
I'll just clarify that. Initially, I was not eligible. Beginning of January. Once they extended it, 1st to 30th
Right,
June.
you are, see, this is the second step. First
Yes.
step was, you said please extend it. Now, second, extend it, and now this is the second step.
No, I'm sorry. I'll just explain briefly in 2 minutes.
Tell us,
Problem
when
is-
Telangana High Court has disposed of the petitions, which is the other High Court seized of it.
Madhya Pradesh? Madhya Pradesh is seized. Madhya Pradesh and
When did the matter come up from Madhya Pradesh?
Madhya Pradesh, 24th of January. 24th and 30th of January.
30th of January.
Yes.
Now when is it listed?
You know the date? Saying what? They disposed of it saying that you can participate. I mean, those who are there can participate. Because they're now eligible by virtue of that second
So
extension.
as on 12th of February, you are ineligible.
That's correct. No, January. Because the second extension is 7th February.
What is the last date? for receipt of applications? 12th February?
12th February.
So therefore, unless the advertisement mentions a contrary date,
Correct.
you must possess the eligibility.
We are all eligible.
12th of
We
February.
are all eligible. There's no quarrel on that.
If you are eligible on 12th of
Yes.
February,
Yes.
where is the question for extension?
So I'll explain. We have to now take the exam on 5th March. Right? Once we became eligible only in February, because we, as per the schedule, we have to do our internship, that last
Therefore, you
internship.
are not eligible.
No, Manoj, I'm sorry. I'm just.
Today you are saying that you are eligible and whatever is the consequence of the internship, we will deal with later. Your real plea is, I don't have enough time now.
That's my plea, but I'm explaining something which I'm sorry, I haven't been able to explain it properly, so I'll explain it. The gap between the exam and the counseling is now 6 months. In the last few years, always the gap has been 1 month. You have the exam and then immediately have the counseling. Now, because of this gap, it does two things. The first is it gives us a very little space for us to prepare. We're working 12 hours, 7 days a week, 65 days a year. That's one. Second, the 19 subjects that we have to prepare for, a large number of them arise from this very intern when we're getting experience. Now, we have only gone about halfway through our internships. So we don't even have that knowledge base at this stage, but that can be repaired. The only thing I'm asking for is give me a little more time. If the exam is pushed by even 6 weeks to 8 weeks, like it was done last year, it was pushed by weeks last year. No, just one minute. I have one more. Counseling, as your lordships knows, your lordships have laid down the timelines. It happens within 6 weeks. Now, just to answer my Lord Justice Datta's point, we're all eligible because we all finish our internships by 11th August. Because we finish by 11th August.
First you say, we are not eligible, make us eligible. Now it is you are made eligible, you say, no, we don't have time.
I'm just pointing out one thing, that eventually, even those.
I
just
here
want to make one small
asking
point.
us to do is to balance on behalf of the
Yes.
examination authority.
No, so I'm just pointing out a small thing. Let's presume that your lordship reject my plea, and there is no change. Eventually, all of us, including those who are initially eligible, 30,000, 40,000, 2 lakhs, they will sit for the exam in March. Then the bill that comes till 11th. They don't have a choice. No, I'm let me explain. Because the counseling can only start after 11th August, everybody sits and waits till 11th August.
Just because you have to wait, those who don't have to wait will also now have to wait.
No, but it depends on merit. The counseling would be based on merit. So somebody
Right. So if they take the exam and you take the exam,
Yes.
merit will be there.
So
Whatever is the position.
No, but
See, those who have been, Mr. Gopal Shankar Narayan, those who have been
when you use
preparing,
my full name, I know I have tested your patient.
the point is, these are slips.
No, absolutely. No,
Those who have been preparing for months together,
yes,
they are told that you twiddle your thumb for another 6 months.
yes.
They may be like you, they may be having employment, they may be also doing their work or whatever.
Yes.
Now, examination, it's not that we are also aware, because when we postpone a judicial exam,
Yes.
the agony which the candidates who are prepared till
No, I agree.
and the entire dynamics changes.
No, I know. But
So we in our effort to anxiety to balance
yes,
your rights,
yes.
one might be trampling upon others' rights.
So I understand, which is why I'm saying this. Just consider one small scenario. Suppose I take part in there, and my friend who was eligible in January takes part in the exam. He finishes an internship, let's presume in January itself. He's finished. Now that person comes first in the exam. We have to wait compulsorily for my internship to get over, because I have to give my internship certificate. That can only happen after 11th August. So when the counseling happens, all of us have to have the completion certificate. Now this I'm not asking a lordship. That's already the rule that's there.
had extended the eligibility condition for internships.
Yes.
Till
Some of us, I mean, not us, but
There was
some people, yes.
Now
That's correct.
that the thing has been done,
Yes.
now you're saying please, increase.
No, I know it seems unreasonable. Last year I was before your lordship asking for that extension which you didn't give me. But I'm saying now the extension is already there.
We are only concerned, we don't know.
Yes.
When we do something and touch this,
Yes.
unless we know how many people are likely.
I have a
others
suggestion.
who are likely.
I have a suggestion. Would your lordships ask the NB to appear? We had served Miss Bhati yesterday. Let them appear and then, because eventually it's still 5th March this time. So your lordship may just get the version of how many people are eligible as of, I can't give those details. I can only conjecture. Madam. I don't have the numbers. What I do have is,
When was the extension granted?
the first time it was granted on 13th January, second time on 7th February.
7th January.
Yeah.
When
They
was
changed
it?
the deadline themselves twice.
No. When was it extended to 11th of?
7th February. 7th February.
Page 17.
That's at page 17 of the IA. There's an additional document.
Just see with Ms. Bhati if she's there. Call her for her. Possibly keep it on Monday. Let her take instructions. Pass it over this.
Thank you, 55.
Over, Chair.
May I please, my notes? This is a present petition, my lords, in which the anticipated bail of the petitioner was dismissed by the Honorable People on 17th of February, my lord. The factual scenario of this case is that the present case was registered under the provisions of 156 Part 3. An inquiry report was filed by the investigation officer, my lord. That is Annexure P1, the status quo. At page 20, my lord. It states that there was no principal offence was given, and regarding the alleged amount, no documentation was given. The present FIR was, my lord, page 20, starts from page 23, Annexure P2, my lord. I am joining investigation as and when called by the investigation officer, my lord, in this present case, abiding by the terms of the 41A. The impugn order states, my lord, that the supplementary charge sheet, because the main charge sheet of the main accused Manoj Jan has come before the learned.
1 minute.
There are 70. I could shut up, please. It's very.
Shall notice. Stay of that best.
I'm much grateful, my lord.
Also, item 25.
Yes. First of all, my apologies, I was not here in the first round. But I'm aggrieved by an order dated 9th of November 2023 of the High Court, by which the revision went out against the order of 30th of August, by which a closure report has been filed and accepted